We're going to start first with the Honorable Daniel Dawson. He was gracious enough to agree to be on this panel. Judge Dawson is a circuit judge here in the 9th Judicial Circuit. I think at this point he is now the longest sitting judge in Orange County on the circuit bench. And he, throughout his entire career, has been a strong advocate and strong supporter of the parties, and particularly children, in child welfare proceedings. So, Judge Dawson, take it away.
Well, good afternoon and welcome to Orlando for those that are outside of the Orlando area. As she said, I'm Judge Dawson. I'm a circuit judge who's been in the dependency system for about 36 or 7 years. I've been on the bench for about 30 or 25 years. The vast majority of that is in juvenile, and most of that was either doing dependency as my sole caseload, or dependency and delinquency. And of course now with Unified Family Court, even though I have a dependency docket, I do have delinquency cases from the crossover kids. One of the things that I want to do to start out, before you get the technical information that you need from the other two presenters, is sort of give you a broad brush explanation of what my view as a juvenile judge is of the dependency system and how that fits into least restrictive means and reasonable efforts, which is really the two concepts that we're focusing on at this presentation. And I want to just set the mood, because sometimes people get involved in the juvenile system, and especially the dependency system, and they try to approach it, whether it's a judge or an attorney or even some of the workers that are involved, in the same way they do in every other division, and it doesn't work that way. In my opinion, the dependency, especially juvenile in general, is really the last equity court we have in the state of Florida. Just about every other caseload that a judge handles, there's checklists and matrix and sentencing guidelines and rules that you have to do A, B, and C, and it doesn't really matter what's best for everybody. If they present the right information or they have the right case law, then you have to rule that way. In the dependency court especially, it is truly, in my opinion, the last court of equity, and it gives the judge a tremendous amount of flexibility, although obviously there are still some restrictions on what we can do. And if you look at the dependency system as a continuum, you start out at one end where parents can safely care for their children. Now, they may not care for them the way you would, or you were brought up, or you would choose, but as long as they meet a certain level of safety and appropriateness, then the government doesn't have any business involving themselves with that. Now, at some point, something happens or fails to happen that allows the government to intervene in that case and to come in and have some control, or at least some impact, on how those parents and how that family behaves. Again, usually there's this gray area where they may not be as good as they should be, but you're not quite sure if it's to a level that you need to impose the court or impose some kind of government order to do something a certain way. Those are usually the ones where you have voluntary services or safety plans, and they try to work it out without involving the court. Then, of course, as you move along the continuum, you get to a point where somebody makes a decision, whether it's a department attorney or whether it's a PI, or sometimes it's a judge. I've sheltered kids directly from my courtroom, and I think most juvenile judges who've been doing this for any length of time have also had to do that once in a while when something happened in the courtroom or some information came up in the courtroom that it was not safe to let that child walk out of the courtroom with that parent, or sometimes it's because there wasn't any parent. If you haven't done delinquency before, you would be amazed at how many kids, 13, 14 years old, the parents put them on a bus and send them to the court to attend their criminal court hearing. Obviously, most of you, or all of you in the room today, wouldn't do that with your child, but that's the way some of the families that we have to deal with in the juvenile system. So once somebody's made a decision to take it into the court system, that's when you trigger a whole lot of the case law and the information you're going to get later in the presentation about the limits on what the court and the government can do once you get into the courtroom. And of course, the vast majority of the cases that come in the courtroom, there's a shelter hearing. Once in a while you do have a non-shelter case, but the vast majority are shelter hearings. The judge has to make a decision whether, yes, indeed, it is not safe for that child or children to be with that parent. And if so, where should that child be? Should it be in the custody of the state or somewhere else? And then if the child is found dependent, you get into case plans and reasonable efforts to try and make the parent safe enough for the child to go home and to be returned to their custody, or if it's a non-shelter case, for the government to get out of their business. Of course, you go farther into the system and you get to the TPR part of it, where some either time frames have passed or certain events have occurred that somebody is alleging that there is no way, or there is not a reasonable way to make it safe for that child to continue to be parented by that particular parent. And as we will see, there's actually, if you look at the statute now, when I started, there was very few parts of the TPR grounds that covered expedited TPR situations where you could go directly to termination of parental rights without going through dependency, without getting a case plan. Now, if you look at the statute, there's far more expedited TPR grounds than there are grounds for going TPR after a case plan or after a dependency finding. So we're seeing more and more cases where there are expedited TPR, where cases are going to termination of parental rights without the offer of a case plan or without the department making reasonable efforts to return or do something to get the parent safe for the child to go home. One of the things that I emphasize, and I hope, and again, because this is a broad brush presentation at the beginning, you really need to make sure as a judge or as a caseworker or as an attorney in the courtroom that you're not just checking boxes. This is truly an equitable court. Every family and every case comes in a different situation. And if you look at the statute, just like in my courtroom, I could probably say 5 or 6% or maybe 10% of the cases that come in my courtroom, technically there would be an argument there's a ground for expedited TPR. There's either been prior removals, there's been prior case plans that failed, the abuse was significant enough that it could be classified as egregious. One or more parents are in jail and may be there for a very long time. But of course, they're not all TPR cases. The department and the other parties involved frequently make a judgment call that in this particular case, we are going to make reasonable efforts and we are going to try and rehabilitate the parents. So the case law that flows to these cases, another thing you've got to keep in mind, and do we have any appellate judges in here? I don't want to, unfortunately, appellate judges, a large number of them, or a large percentage of them, never were trial judges. They went directly from private practice to the appellate bench. And I have talked to appellate judges who, they do have a process where they can sit on the trial bench if they so choose every once in a while, just to get a flavor or get a feeling for what it's like to actually sit there and make these decisions day in and day out. And I've talked to some of the appellate judges who've taken advantage of that, and they have frankly admitted that that really changed their perspective when they see these cases, especially juvenile and very especially dependency cases come up before them, that they now realize why the judge and why the parties were doing what they were doing in the courtroom. In a very sterile appellate analysis, it didn't make sense to them. And that's why you get some of the case law that you get. It's not because they don't care about kids, it's not because they don't care about parents or whatever side they fell on. It's because they're judging these cases on the appellate level just like they do the civil cases, the domestic cases, the criminal cases, all of which, if you don't meet X, you then get Y, and that kind of thing. And so, unfortunately, we do get some case law that's not the best in the world, and that's why it's so, so important when these cases do go up on appeal that the parties properly brief them and properly argue them. Because we've had a few cases, I've had a couple of cases where appellate attorneys confessed error on cases where there wasn't an error. And of course, if you confess error, they send it back. And it's like, wait a minute, that's what they confessed to isn't correct. So it is super important for the appellate level to make sure these cases are properly litigated and they're properly heard. But what you really need to keep in mind is that a lot of the judges that are making these decisions and making these rulings have not been in the almost none of them have been in the juvenile court, even if they've got trial court experience. You know, juvenile judges don't make the appellate bench. I can count on one hand the judges on the appellate level that have ever sat on a juvenile bench, and most of the time those judges were only there because they were forced to be there because of the rotation. It wasn't their first choice, and then they made their way to the appellate bench. There's really two good reasons for that. One is they just don't get a lot of consideration, and number two, the really good juvenile judges, a lot of them want to stay in juvenile, and if you stay in juvenile most of your career, you don't have the broad background that they sometimes want to move you up to the appellate bench. So a lot of the really good juvenile judges are going to stay in the trenches, and you're just not going to see them on the appellate bench. The other thing to keep in mind is the Supreme Court is in the same situation. A lot of the Supreme Court justices never were in a trial court. There was a one period of time not too long ago where none of the Supreme Court justices in Florida had ever been on a trial bench. It was a very short period of time. But there was one point where none of the judges that were up there making decisions on what happened in a courtroom had ever actually sat and been in a courtroom and actually experienced the things that went on there. Clearly, once you get to the end of this continuum where you're now in a TPR situation, you are making a decision that's going to impact the child for the rest of the child's childhood and perhaps the rest of the child's life. And you're clearly making a decision that's impacting the parent for the rest of their life. You know, you're permanently removing a child from their custody. As you're going to hear, once you get to that point, obviously the first choice other than in an expedited TPR situation is reunification, return the child to the parent. Where the least restrictive means situation has come up in the cases that are going to be talked about is once you are not able to return the child to that parent, are there additional hurdles you have to get over to get to the next preferred permanency, and that is adoption. And then, of course, if adoption is not selected, you go to the next one, which is generally permanent guardianship, assuming the child's been placed outside the foster care system. And then, of course, if the child's still in the foster care system and you're not going to terminate parental rights, then they end up aging out of foster care, APLA as we call it, or as it's called, and they do not leave the system. So, just to make sure it's real clear, in the broad brush I'm giving you is that you start out at one end where we don't get government interference, we then get government interference, we then get to a point where we have to find permanency for the child, and we have to make a decision, is it expedited TPR or have we made reasonable efforts? Now, the one other thing I want to bring up is under reasonable efforts, sometimes under the expedited TPR, there is a question about whether you should or should not have made reasonable efforts as it falls under the best interest of the child or manifest best interest of the child portion of the trial. So it's not totally out of the equation. I have many cases where they technically have TPR grounds. They've had a prior involuntary TPR, they've had prior children removed, but based on the current status of the case, it may be in the manifest best interest of the child to try to salvage the parental relationship. And of course, a lot of that has to do with how old the child is, what the relationship is with the child and the parent, what the options are. whether there's a relative available, whether there's someone that might want to adopt the child available. I've got kids that don't come in the system till they're 16 or 17 years old and obviously or may not be interested in adoption, so those you pretty much are stuck without a termination of parental rights, or if you do, you're not going to end up with the child being adopted by somebody. So the reason I wanted to start out was just to sort of give you the view from a juvenile judge's point of perspective as to what I'm looking for, what I expect to see happen, what I'm hoping to accomplish in the cases that come in front of me. You're now going to hear the technical arguments and the technical information about how to do your job in the courtroom when you're in there either as a judge or a litigant or one of the workers.
Thank you, Judge. My name is Dennis Moore. I'm the General Counsel for the Statewide Guardian Ad Litem Office. I began in this field in dependency and child welfare in 1999, actually. And Judge McKibben and Alan Abramowitz, I worked for them. They're the people that brought me into this. And here I am today thinking I'd only be there about 6 months maybe, and then I move on. But I then moved to a legislative pilot project that was studying the effects of representation of children in the dependency court system. And that's when I went to work for the Guardian Ad Litem Office in the 9th Judicial Circuit, practiced in front of Judge Dawson's, in Judge Dawson's courtroom there. When the statewide Guardian Ad Litem Office was created, I became its first general counsel. And at a time I did manage to leave this, and I was in private practice. I worked in the area of labor and employment law and did appeals for banks, if you can imagine that. And so then I found my way back into the child welfare world because primarily it's just fantastic work, and it's very frustrating, but also very rewarding. So, so with that in mind, just to pick up where Judge Dawson left off in the broad view, it's good when we're going to talk about a technical issue that's in front of us, in my mind, to sort of work your way to it through the broad picture. And what we're going to talk about here today, the least restrictive means test, is really one element, as you know, of the termination of parental rights here in Florida. You have to have grounds, you have to demonstrate the manifest best interest of the child, and you have to demonstrate that termination of parental rights is the least restrictive manner in which to protect this child. So as we begin here, an overview of dependency proceedings that Judge Dawson just get in that just a little bit, spend a little time on that. Judge Dawson has told you that dependency court is really one of the only remaining equity courts there is, and that is very true. And the reason why is because it's an exercise of the state's, pure exercise of the state's parents' patriae authority to protect its citizens, specifically its children. When the children are removed, they're placed under the jurisdiction of the court pursuant to Chapter 39, and the state's exercising police power under that doctrine, and it continues to do so until such time as the child's reunified jurisdiction is closed, or until we find some other means of permanency for the child. The interesting thing about it when this happens is it places the court in a position where it is now, as we say in loco parentis, with the child. In other words, the parent can no longer exercise reasonable judgment for the child. That's why the court removed the child. And so now that places really the court and the department, in some sense, in the shoes of the parent in those day-to-day decision-making situations. And yes, it's a Latin term, and usually you know that lawyers are really, about really to do something really incredible when we speak in Latin. But that's technically what's going on in dependency court. That's where the equity Judge Dawson was talking about is technically derived from. And it's the court. The interesting thing about it is it's the court that's in the position of protecting the child's interest, safety, welfare, best interest throughout this process. There are I look at it this way. There are certain choke points where the court has to act as that referee that we all understand judges to be in most proceedings, civil proceedings, for example, and criminal proceedings. For example, when they're adjudicating rights, shelter, dependency, termination, reunification determination decisions regarding reunification and these things. That's where the judge then has to put more of the referee hat on. But other than that, the judge is exercising broad discretion. 39011 illustrates this and clearly directs the court, the legislature is clearly directing the court to exercise that discretion to protect children that are under its jurisdiction. Okay, so with the understanding of the nature of the proceedings in mind, and we have constitutional issues that are coming to bear on us, the first thing that you have to determine when you're dealing with constitutional rights is the nature of the right itself. And those of you that are constitutional buffs, we won't get that deep into it, but it's Matthews versus Eldridge and those lines of cases that we all, the lawyers out here studied in law school that give us the understanding of the balancing of interests when we're talking about rights versus the state's interest, which is what we're going to be dealing with here in these termination of parental rights proceedings. So the nature of the right springs out of the seminal case really on that is Santosky versus Kramer. If you do any amount of appellate work or in this area, then you have read this case, I'll say ad nauseum, and it clearly lets the general public know that this is a fundamental liberty interest that we're talking about. Santosky also, what sprung out of Santosky was the notion that it's a fundamental liberty interest. It's not a restriction on personal liberty, but it's significant. And you also have, so that's where the balance with the child's rights and the parent's rights really come into play. So when you have a termination of parental rights, as you know, you have to show by clear and convincing evidence that reunification poses a substantial risk of harm, and that the state must establish that termination is the least restrictive means of protecting the harm. That came out of the Padgett case that we have to follow when we're attempting to terminate parental rights. The thing that you have to understand about parental rights is they don't just come with the right to exercise control or the right to do certain things. Frankly, if you want to think about that and go back to ancient law, that's really more of thinking of children as chattel. But as we move forward, what we're seeing is that the court is recognizing that not only do you have possessory rights, rights of control, but you have obligations as well. And the problem comes when parents do not meet those obligations or don't take care of those obligations, and then the state has to exercise its authority in order to intervene to do that. The most recent case on this topic that came out of the Florida Supreme Court, SM versus DCF, was pretty clear on this particular issue. You can go back to 1974 in M. Ray Cam. This is another case. If you've been around this a long time, you've heard this name several times. And this, again, was the genesis, one of the genesis of the determination that parenting was actually a fundamental liberty interest. But it also had the theme that has been taken through all these other cases that we've seen in the development of the law in this area, which indicates it's ultimately the welfare and best interest of the child that has to prevail in these cases. So the only limitation then on the parental privilege, if you will, is that between the parent and child, the child's ultimate welfare is going to prevail. And this is important when we do the balancing of interests for due process. Okay, I know you're thinking, Dennis, are you telling me that just I can terminate kids' rights based on best interest? Well, if you do that, you'll get the look from the judge like that one there. So, I mean, I'm trying to avoid that. And so, no, you don't want that look. I hate that look. But anyway, due process is what you balance against the best interest in order to protect parents' rights. The most recent legislative session, the one that just passed, the legislature was analyzing a bill. It was a bill regarding adoption interventions. And they reiterated this concept, and the concept of what dependency court was. and stated pretty clearly that within the construct of the dependency court, parents do not have really the right to unilaterally direct the decision-making of their children until they resolve this dependency matter, and the state determines that they will protect the child's safety and welfare. And so, but they do have due process rights. And the due process rights have to be protected by the court. Department of Children and Families as well has to protect the due process rights in the proceedings. When we think about due process, just some basics here. Due process is the vehicle to assure fair treatment. I mean, that's when you think about it, that's really what it is. Again, sprang out of Matthews versus Eldridge, but this case here really just says it. That's really what due process, as I think of it, really what it is. The procedural component of due process, and when you think about it, it requires a minimal level. Now, when you say minimum level, that's where you start balancing it against the interest that the state is trying to protect. And so, what we've said in the past is that, and what I have learned is that due process is a floor, not a ceiling. For example, when the United States Supreme Court in Lassiter versus Department of Social Services says that that we're laying down a rule regarding ineffective assistance of counsel, and the rule basically is only when you're going to lose your parental rights are you entitled to ineffective assistance of counsel. What they also said is we are setting this as the floor. States might be wiser on this topic than we are, or might want more protections than we do, but this is the floor. And so that's really what we're thinking of. And so in dependency, you have this other interest, the safety, welfare, and best interest of the child. You're always balancing against the severity of the due process, or the degree of due process that you're going to put into the case in order to protect the parents. And the struggle there comes between getting a right result, the right procedural safeguards to get result, primarily versus permanency and the time to permanency. That's always the issue and the underlying issue for the most part against due process in the dependency system. So due process rights are flexible, and they require that the proceedings only be essentially fair. That just really speaks to the fact that you can't ensure perfection, and they're not going to overturn cases because it wasn't perfect. But if it's essentially fair, that's going to be the overriding test for due process once a case goes up on appeal. And again, it's not a rigid requirement. It allows for flexibility. And this is the Lassiter case. And flexibility and economy isn't always sacrificed. And they were talking here about a dependency case. So the flexibility and economy that you find in the equity court portion of what's going on, what Judge Dawson was talking about, they don't want to sacrifice in order to keep getting closer and closer to a perfect result in terms of the proceedings. So the least restrictive means prong is really tied to due process. When you think about least restrictive means, all we're really doing is we're protecting parents' due process prior to the filing of the termination of parental rights petition. And so this only comes in to play when parents have not met their obligations. So what is the least restrictive means test actually? It requires less severe action or other than termination of parental rights if it would allow the child to be reunified with the parent. And this issue came up recently in a decision that came out of the First District Court of Appeal called CD. In that matter, the court basically determined that the permanency options contained in 39 were different levels of restrictiveness, if you will. In other words, if you could have a child in a guardianship, that was less restrictive than terminating. And so SM decision said, as we will see later, is that that's not the case. That's not what least restrictive means is tied to. Least restrictive means is tied back to what the parent did do and what the court and the state did prior to the termination of parental rights petition being filed. So the issue is you have to be able to reestablish, short of termination, the parent-child bond. That there has to be a demonstration that that can definitely be done in order to not meet that test. But so let's look at what the test isn't. The test isn't whether or not, as we said, there can be any contact with the parent, or whether there can be some minimal contact and the child remain safe. The test is whether or not the child can be safely reunified. And the reason why is because the lives of the children are too important, so says the Florida Supreme Court, and so we believe that their future can't be sacrificed. So if we can get a child adopted, get a child a family, and there is no reasonable belief that the child can safely reunify with a parent in the reasonably foreseeable future, I believe that's what the SM opinion really stands for. It's not, and so it's not intended to preserve the parental bonds at the cost of the child's future. And again, as we've said, it's not whether available alternatives are going to allow the child and the parent to remain in some sort of relationship. And the interesting thing about the evolution of this law from the CD case I mentioned is this was the next case in line in this in the development of this issue. And in this particular matter, they looked at the CD case, the 5th District did, and they said it really misconstrues the Supreme Court's rationale for the least restrictive means test. Because, as we said, it's not available alternatives. It's whether or not you can actually reunify the child. And with that in mind, we moved forward into the 4th District Court of Appeals, which picked up on that logic and determined that the test is not whether the circumstances of the parent can have any contact, but whether it can be, they can assume the responsibility. So it goes all the way back to, as we said, parental rights comes with assertive rights that you have, but you also have obligations. And so in the end, the least restrictive means test is tied to, can the parent be put back in a position that they can exercise those obligations and protect the safety, welfare, and best interest of their child. And that's what the least restrictive means test focuses on, not the other. And this again was the BC case, which really bolstered that opinion in the same vein, saying that highly restricted contact was not the touchstone of whether or not least restrictive means has been satisfied. So in disapproving the CD opinion between the 4th District and the 1st District, what the Supreme Court said is the bond that a parent might have with a child is really more properly considered under the manifest best interest portion of termination of parental rights, and not a determination of whether or not the permanency options such as guardianship would allow you to say there's a least restrictive alternative to the termination. Also, this case also pointed out that the that are listed in 39621 are listed in order of preference, and so you have to have reunification, as we know, if that's possible. Then the next permanency option in order of preference is adoption. And if you're not going to adopt, then 621 requires a finding of best interest as to why you can't do that to move to the next one, and so forth and so on, all the way down to another permanent plan living arrangement in our permanency options. So the proper focus of least restrictive means is on the state's action prior to filing the termination of parental rights petition. So did the state, has the state done what it can to try and safely reestablish the parent-child relationship? That's really what it boils down to. And again, ultimately, SM stood for the fact, reiterated those facts through those other cases that we had discussed, Cam and Santosky, that the overriding concern for the dependency court is the child's best interest. So in the end, the fact that there's no less restrictive permanency option, that's not the test for least restrictive means. And I think with that notion we'll move on, and I think Thomasina is going to talk to you more directly about case planning in some instances.
Hi, I'm Thomasina, and I'm a legal nerd, and that's why I'm here today. My husband gave me the book, The Constitutional Parent, and I liked it, so we're going to talk about that. Judge Dawson gave us basically the overview of the dependency system and how it fit within the legal framework and the overview of it. Dennis went more through the least restrictive means and how that fits into TPRs and establishing that it's a test of whether due process was given and looking at whether the state's actions prior to the filing of the TPR were sufficient to satisfy the least restrictive means test. I'm going to walk through now and give you some more of the nuts and bolts of applying that during the case itself, looking at case plans, case performance, and then ultimately TPR. So again, ordinarily, in order to terminate parental rights and meet the least restrictive means test, the state must show that it has made a good faith effort to rehabilitate the parent and reunite the family, and ordinarily that is done through a case plan. The test is presumptively met when termination of parental rights is based upon the failure of a case plan. Section 390176 defines substantial compliance, and I will, as a caveat, tell you there is a bill pending right now. It's HB 1044, I believe, which may change this definition some, so watch the legislature. But right now, substantial compliance means that the circumstances which caused the creation of the case plan have been significantly remedied to the extent that the well-being and safety of the child will not be endangered upon the child's being returned to the child's parents. It's not necessarily every aspect of the case plan, but the reasons that they were brought into care were significantly remedied. Substantial compliance, conversely, the failure of the case plan and substantially to comply with the case plan means the circumstances that caused the creation of the case plan have not been significantly remedied, and the well-being and safety of the child will be endangered upon the child being returned to the parent. That brings us back to the concept that the state is acting in loco parenti and that they are looking at the best interest of the child, because the only thing that can override the parent's fundamental liberty interest is the safety and welfare of the child. If reunification is not possible because the mother or father cannot or will not assume responsibility or simply can't, repeated failure to comply with a case plan, then termination is the least restrictive means of preventing harm. In spite of the name, the least restrictive means does not mean that no alternative to termination of parental rights is, or any other alternative is available. All right. Where the case plan is given, the only factual analysis is whether the parents received a constitutionally adequate opportunity to substantially comply with the case plan. I'm going to just pause on this for a second, let it sink in, because that's a heavy sentence, but it sums it up very well. It's a factual analysis when you get to TPR of whether the parents had a constitutionally adequate, which is fair and reasonable, opportunity to substantially comply. In this way, I'm going to compare due process to what I think we're all familiar with, and that's notice and opportunity to be heard. We all know that if you have a motion filed, the other party has to have a notice and opportunity to be heard, or they did not get due process. You can think of that with terms of least restrictive means. The parent has to have the case plan, and an opportunity to complete it. And in that way, you can analogize those two due process requirements. The trial court, when it's determining whether or not it was met, should focus on DCF's actions prior to filing its petition and determine whether the parent's due process was afforded. It is improper for the trial court to look beyond the date of the petition to determine that with some possible future, the parent, and additional time, the parent might improve and work towards reunification. We see that a lot. Trial judge, in their opinion, has said, maybe with a few more months, right now at the very end, the parent has decided that they're going to take a class or get the counseling they were supposed to get. I think if we gave them more time, maybe that would work. That's not the proper test. The proper test is, where were you at the time the petition was filed? That is not to say that if a parent needs additional time to complete case plan tasks, they shouldn't be considered. But that's case plan amendment, and we'll get there. In egregious abuse cases, least restrictive means does not require a parent to be given a case plan because it's basically determined that there is no safe reunification. There's no task that somebody could do that would remedy the problem. Termination is the least restrictive means because it's the only way to protect the child from harm. And again, the harm and the child is the overriding interest. Section 39-8062, which says that under certain circumstances the case plan does not need to be given, does not eliminate the burden to prove termination, is the least restrictive means to protect the child. Here, this is a recognition under the different various statutory sections which are listed under 8062 that different types of evidence in different circumstances have to be considered for due process rights. For instance, one of the subsections referenced is abandonment. You don't need to give a case plan for abandonment because there's no parent there to give a case plan to. That's very different than a case where there's a murder of a sibling or something else where the conduct was egregious and there's no reason to give a case plan. Due process is going to vary based on the circumstances before the court. How do you make sure a case plan meets the least restrictive means test? Luckily, Chapter 39 has a whole lot of that built in for us. Chapter 39 has the due process safeguards that are found in case planning. These are only a few of them that I've picked out, but ones that are significant to what we're talking about. Section 3901, case plan development. Parent may receive assistance from any person or social service agency in preparing the case plan. That's important here in this conference because a parent with a disability might need some assistance in formulating the case plan and understanding the tasks. That would be part of due process because that's part of the reasonable opportunity to comply. So it's built right in with a procedural safeguard there. Case plans have to include the date of compliance and the period it expires. The case plan must be limited to as short a period as possible for accomplishing its provisions. There's the balancing test. You want to give them enough time to comply. Usually it's going to be 12 months is the default period, which is federal law maximum. But at the same time, you want to consider that it needs to be as short as possible to accomplish this task because you don't want children languishing. Case plans must include the date the compliance period expires. That is a procedural safeguard built in because that gives the parent the notice period of when do they have to comply by, and the opportunity to comply is going to end at this particular date. They know that if they can't comply within that time frame, that they're going to need to ask for more time and then go in and see why. A written notice to the parent has to be provided. Again, due process, notice. That failure of the parent to substantially comply with the case plan may result in the termination of parental rights, and that also a material breach of the case plan may result in the filing of the petition for TPR. This is all giving them foreknotice of what they need to do to fulfill their responsibilities and their duties, which SM, that's one of the first most clear statements of the fact that the parent has, along with its rights, duties, and that they do have duties to comply with case plans and do what they need to do to be reunited safely with their children. After the case plan has been developed, the department has to adhere to the following procedural requirements. And here is where we get to where the department and what the state has done prior to filing of TPR. The statute has many provisions on the department's duties in addition to this. And the main one, though, is provision of services to the parent or the child and parents agree to begin compliance with the case plan before the case plan's acceptance by the court, and the department shall make appropriate referrals for services that will allow the parents to begin the agreed-upon tasks and services. So the department has a heavy burden here to assist the parent in completing their tasks. And that is something that, as we go along, if the department is not fulfilling its obligations, the parent has remedies for that, and the court does as well. Section 396012 case plan tasks also say, and this is where you are, again, built-in procedural due process, the services offered must be the least intrusive possible into the life of the parent and child, and must focus on clearly defined objectives, and must provide the most efficient path to quick reunification or permanent placement given the circumstances of the case and the child's need for safety and proper care. You've got everything in this little section of what we're talking about. You've got the least intrusive means, clearly defined objectives so they know what they need to do. You've got the most efficient path to reunification, time, permanency is important, and child's need for safety and proper care is the overriding factor. That kind of wraps almost everything into that one little paragraph. The case plan has to describe each of the tasks which the parent must comply and the services to be provided to the parent, specifically addressing the identified problem. These case plans, again, due process is dependent upon the circumstances. You want your case plan to match the reason why you're there so that they can show that they have significantly complied, which is remedying the reason they were brought into dependency court. So being specific with it is another way in which we're meeting the due process requirements, and also making sure that the parent has the ability, by being specific, to meet their responsibilities. Practice tips. Parents should request the services they need at the case planning conference. If you need services, you should ask for them. If, when you're getting the services, you need accommodations, you should ask for them. Make sure that you are letting the court and the department know, when you have that meeting, what you need in order to be able to comply if you are a parent. Case plan should include a provision that the parties will notify the court of the failure of the other party to comply with the case plan. You can write these case plans or contracts. You can add this clause so that you don't get caught at the end where someone is saying, well, you know, I didn't get the referral I needed. I didn't get what was supposed to be provided. If it's in there and you're telling them, give us notice ahead of time, then you can prevent a situation where time is going by and going by and going by, and you, the parent, aren't getting what you need. Case plan amendments. Amendments have to include, again, service interventions that are the least intrusive into the life of the parent and child. Focus on clearly defined objectives and provide an efficient path to quick reunification and permanent placement given the circumstances. Same as before. It ties up all those things that are needed. And remember this with case plan amendments, because, again, if you're getting to the end of your case plan, prior to filing of TPR, because that's going to be a cutoff date to look at what you did, if your client, if you represent a parent, thinks they need more time, go in and tell the court. If, as the department, you need more time, go in and tell the court. If the guardian ad litem thinks that there's additional services which should be given because it's in the best interest of the child, go in and tell the court and amend the case plan to include those provisions. That way, everybody's on the same page. Case plan performance. Again, parents have responsibilities. Parents whose custody of a child has been taken must take prompt and substantial action to achieve reunification with their children. And that was, again, what I think one of the most important pieces of the Supreme Court opinion was setting forth those rights and duties. Now remember, these case law focus on parents' responsibilities, but the department has numerous duties that are set forth in the case plan provisions of Chapter 39. So each party has something that they have to do. Practice tips for case plan performance. Judicial review hearings should be utilized by the court to inquire regarding case plan performance. If you're the magistrate, if you're the judge, and you have the parties in front of you, ask them, is the case plan moving along? Are the services being provided? Are you having obstacles to being able to provide the services? And this way you get it out there so that when it comes time to terminate, if you get there, and you won't necessarily, that all of these issues have been hashed out prior to the actual hearing. Any obstacles to the parent's ability to access required services or perform the tasks. If you have a reason you can't, bring that out as well. Not just services, lack of referrals, but you have some reason why you can't perform. Application of the least restrictive means at TPR. Okay, first, just as a note, when parents enter into a consent to the petition for surrender, that is also a consent for least restrictive means, and that cannot be appealed. So when they sign the consents, that also includes least restrictive means. Okay. It is error to prioritize the parent's rights over the best interests of the child and delay permanency. By the time that you get to the termination of parental rights hearing, your chance to substantially comply under the case law is cut off at that point, at least as far as the court's factual analysis. Remember Judge Altenburn in Ray's ZC, as to whether or not you were given the constitutionally appropriate case plan. Performance is cut off, whether you were given the right case plan is cut off. So at this point, if parents want to come in and they say, I need more time, if they were given the constitutional case plan and the opportunity to comply with it, then it's an error to prioritize the parents' rights and say, well, I think with a few more months, then they might get there, over the interests of the child. Because going all the way back to the beginning in the parents' patriarch concept, even against fundamental liberty interest, it's the rights of the parents that take, or rights of the child that take precedent. If the parent has had an ample opportunity to comply, belated attempts to become a good parent amount to too little, too late in terms of the least restrictive means test. So make sure everybody's proactive, and that's what I'm saying. Begin at the very beginning with the case plan and with making sure you get what you need put in there. As you're performing it, when you're going through the JR reviews, make sure that what you need is being given to you as a parent's attorney or DCF, that you're bringing the inability to provide those services to the court's attention, because you don't want to get into a situation where belated attempts are too little, too late if you represent the parent, because the best interest of the child and permanency is going to control. If parents have not expeditiously taken steps to preserve their rights, services should not be, or services, and there's a little goof there, I'll fix it when we send it out, should not be able to delay permanency for the child. The 4th District just yesterday actually entered a new opinion, and in that case, the prospective biological father came in and moved to intervene on the eve of the TPR proceeding. In that case, the father had known a year and a half before the TPR proceeding that he needed to take steps to affirm his rights and to demonstrate that he was actually the father, and did not until 2 months before the hearing. The court said no, the prospective biological father needed to act with more expediency. The legislature has stated that time is of the essence in these cases, and at the time of the prospective biological father's motion to intervene, the child has spent his entire life in the dependency system. He deserved permanency, and the trial court did not abuse its discretion by not further delaying the proceedings to accommodate a potential biological father's rights. So here again, the least restrictive means, to sum it up, it is a due process consideration. It is a test of whether you were given those due process rights. Due process is going to be whether or not you were afforded a constitutionally sufficient case plan, and whether or not you were given the means by which to complete the case plan. Once the termination is filed, the district courts have said that it's an error to be forward-looking. You look backward and see were they given those chances, and delay is not in the child's best interest, and permanency in the child's best interest, going all the way back, Santosky, all the others, controls. So take the steps you need to make sure through case planning and performance that you get the what you need for the father, that DCF is bringing it forward, and that it's all set up by the time you get to the TPR hearing to be able to do that factual analysis. With that, we're going to either do some hypotheticals, we have a few minutes, or unless anyone has questions first. Okay, Judge Dawson and hypotheticals.
Hand over here.
Oh,
Let
okay.
me, I just wanted to real quick before we take a question. Did everyone get what was just presented? Does everyone understand it now fully? Okay. Let me tell you, as a juvenile judge, what I heard in like a one paragraph presentation I got out of this. Number one, least restrictive means is a constitutional concept, not a finding. So, and it starts at shelter. I can't shelter a child if there is a less restrictive method to protect that child and keep the child with the parent. And then it moves through the case. When you get to TPR, if you have grounds for termination of parental rights that are found by clear and convincing evidence, at that point there is a presumption, as it applies to the parent, that this is termination of parental rights is the least restrictive means to protect the child. Now, does that shut the door? No, you still have manifest best interest. And especially in the technical expedited TPR petitions, you may have, as a parent or a parent's attorney, have an argument in that portion of the trial that this is not the least restrictive means in order to protect the child, and this isn't the best way of doing it. But at that point, it's my opinion, it shifts to the focus of the child. Is this the least restrictive means in the best interest of the child? So if you make a finding by manifest best interest that no, termination of parental rights is the best interest of the child, manifest best interest, then least restrictive means does not prevail. They can't win that on appeal. So I know I still have parties in my courtroom that come and ask me to make a finding of least restrictive means, and I keep saying I don't think I have to do that anymore. Now at the Supreme Court, SM, it's no longer a legal finding, it's a constitutional concept. So in a nutshell, that might tie it all up, at least from a judge's point of view. We have a question, I think.
It's a question on case plans of whether or not they have to be signed by the parties to be binding, accepted by the court.
The question is, as a contract, does a case plan need to be signed by the parent and caseworker to be binding if it is accepted by the court? If the party, especially under oath in the courtroom, agrees to the case plan, and therefore the court accepts the case plan and orders the case plan, I've never seen a case that said you could go back and cancel or reverse that case plan because it didn't have a signature page. I don't know if I know we have a few judges in here, I don't know if any of them have had any experience with that where someone tried to challenge it later because they were in court under oath and said, yes, I agree with the case plan, and then later said, well, oh, but I caught you, I didn't sign it. We're 9 months down the road. So my response would be, now, if you don't have them there, and their attorney just says, yeah, my client agrees, you may have a bigger problem if the client comes in later and said, no, I didn't tell my attorney that. Because then it's really hard to look behind what did they say or what did they not say, and the attorney can say, well, I misunderstood, I thought they said it was okay, but apparently not. But the specific answer I would have is, that it would not negate the legality of the case plan.
Doesn't the wording of the consent help that anyway? Because you're not admitting or denying and you're agreeing to the services that have been recommended, and then we order the case plan. Obviously, I inquire with the parents at the consent, but the consent is pretty well fashioned.
Well, I think unless you went through every task on the record, they could argue, wait a minute, I didn't know I was supposed to get a psychiatric evaluation. I would have objected to that. My attorney never told me that. I never signed that. I never saw a copy of it. You might have a little difficulty down the road when that's the only thing they didn't do, and that's what you're moving forward with a failed case plan. So I try to get signature pages signed by everyone in every case that I can. I do realize once in a while it's either, slow down and get that or go through or just accept the fact that on the record they say, yes, I've reviewed it, yes, I agree to it, and I will accept that, and then in my order, I approve the case plan. It's probably best practice to get the signature. They say, I've never seen a case that a TPR or some other issue hung on that, and actually, as far as I can recall, in all the years I've been doing it, I don't recall one where somebody came back later and tried to challenge it, but I'm not saying it couldn't be. You know, they challenge it on everything else. You know, when you get desperate, you do whatever you have to do to try to win your case, whether you're a parent or attorney.
I have about 10 minutes. Do you want to do a hypothetical? Or, oh, I'm
Well-
sorry. Do we have another question? Did I miss it?
Yeah,
Sorry.
you got that mic, right?
Thomasina, you mentioned in your presentation that there's a statutory provision saying that parents can receive assistance from, it said any person in preparing their case plan. Does that include the parent's attorney?
I wouldn't see why not. The statute's pretty broad, and I think it was written and intended to be broad. I think you may have an issue later as the attorney if the parent comes in and says, you know, you advised me to do a certain thing or not, but that's going to always be true anytime you represent a client. So I can't see any reason why you wouldn't be able to.
And also, we as the other side of the aisle, if there's a claim being made that the parent didn't get assistance, we may have some trouble trying to establish what their attorney told them, because that's obviously privileged.
Well, yeah, you can have a hard time with what their parent did or did not find out from their attorney. However, I think that in that instance, you might also be able to take advantage of what's known as the sword and shield doctrine, where you can't use privilege both as a sword and a shield, so that if the parent is coming in and saying, no, I wasn't told this, or raising the issue of what they were told by the parent, then you do have the ability to inquire regarding that if they put it at issue themselves in the litigation. Any other questions before, or hypo? All right, let's do a hypo.
Well,
Here, you want the microphone?
I can step up here. I had several very detailed hypotheticals, and probably some of you that are from the Ninth Circuit would recognize some of the facts. I kind of tried to blend some of them together. But a couple of them, and this is more of I wanted to throw it out as a concept. I think where a lot of times we have a lot of trouble with least restrictive means is when you have a parent that can't comply with a case plan because of incapacity, whether it's mental health or whether it's actual injury. And so I've had a number of cases, have some right now, where it's not a matter of the parent not being willing to comply with the case plan, but they're unable to comply with the case plan. So as far as least restrictive means, anyone want to take a guess at, yes?
Well, it reminds me of a similar case that I had at one point, and the mother was in a wheelchair bound, had cerebral palsy, and the child in the case thought that if she harmed her mother, that she might get a new mother, a new normal mom. The whole case kind of just, there wasn't really much going on besides therapy, therapeutic interventions and things like that. But ultimately, at the end of the day, that parent could not protect herself and the child, and eventually may have had to take some protective action that would have harmed the child if things escalated again, if they did time of shelter. So we ended up closing that case to permanent guardianship. There was, some requests for discussion about potential termination of parental rights, but I just think given the fact that she suffered from this significant physical disability, it wasn't about the fact that she didn't want to care for
Right.
the child. She was just completely unable to. And it turns out that, this child was only 7 years old. Who's to say that 10 years down the road, that child might not understand, hey, my mom's not different in any way. She just has this disability.
And that, you bring it, that would be one of the points I would bring up is, does it make a difference if they're 2 years old and their parent can't care for them, or if they're 17 years old and their parent can't care for them, as far as least restrictive means?
Yeah, I think that's a good, I mean, that's really a severe case. I mean, that's one of the that's one of the more complicated cases, as you all know. And I think, I mean, just analyzing that, I mean, what process could you give her, you know, is what you're saying. I mean, what process would she rightfully?
I mean, that was one where the case manager and I, we shared a tear after that one.
Yep.
That was a tough case.
Sure.
Tough resolution.
I know, and it's weird to think about it, but that is a good thought, because it kind of really makes you think about due process and how you balance these interests. You know what I mean? Because you're not balancing it in a bad way. It's almost like you're not giving her due process for her own benefit. I mean, that doesn't make sense, you know, but it seems to almost work out that way.
And I think that's a great example of, it sounds like you really worked with the case manager and came up with the best solution given the circumstances of keeping her parental rights intact and doing the permanent guardianship so that you could provide the safety for the child and the mom both. And that is absolutely heart-wrenching to be in the position of doing that.
Yeah, and let me say this. I think that what you did there, in my mind, and I've been involved in something similar, you know, but you know, it's almost like that's where the flexibility, the informality of dependency court, that's where it's helpful, you know, because we're not going to then just back away from that situation, start filing motions, you know, I mean, here's my request for admissions, and to get at the root of how to solve that problem for both the parent and the child, so.
But what would you have done if the judge said, no, this child's only 7, I'm not doing a permanent guardianship because this parent will never be in a position, I'm not having a kid in limbo for 11 years?
Well, it sounds like at that point, I probably couldn't avoid the change of the goal, and I probably would, at that point, go back to the drawing board and reassess with the team, you know, as to how we're going to move forward. But honestly, it would just take some, I think at that point, I would pull everybody together and try to have a real therapeutic type discussion about, you know, how we're going to move forward and try to balance the interest of the court. I mean, the court brings a good point up, I think, if they make that ruling, and luckily, I would say we didn't have to address it in that case, so I'm fine.
Those are the toughest ones for me. The ones where the parents clearly could have done something and didn't, you know, that's not that tough for me, or they committed an egregious act. The ones that are the toughest are either where they have they're put in a position where they don't have the capacity. I have a case right now where the father was arrested, and it turned out he's an illegal alien, and he's probably, even if he beats the criminal case, is going to get shipped back to Mexico. So realistically, he's never going to be doing a case plan here in Orlando. And the kid loves him and wants to be with him, and you know, the question is, you know, what do you do on that case? There's a million more facts on that case than just that. But that's just an example of a case where you have a parent that just can't do a case plan. They can't comply, and you have to, at what point does it shift from the due process of the parent to the best interest and rights of the child to have a permanent home? And of course, legislature have said that adoption is the first choice if it can't be reunification.
Wendy, do you have a?
I would argue that if a parent can't do a case plan, that shifts it out of an ordinary case and out from under Padgett into in-rate TM, and you use a different ground than case plan non-compliance. Because as Dennis said, it's the ability to parent. That parent
Right.
cannot parent, so that shifts it to the extraordinary, and it moves you into lack of, where you don't need to make reasonable efforts. I would technically argue that's a C case, not an E case.
Yeah, and I think the judge gets at that through his case and that hypothetical, because the further it gets that way, in my opinion, the further back you get. Like if you've got a small child, like a 4-year-old, I mean, now you're in a situation where the courts are saying you're sacrificing the future of the child. If you've got an older child, and you know what I mean, and you've got a guardianship, in that, you know, in that situation would be of best interest, then you've got that. But that gets to think of what you're saying, and where there's no, I mean, that would be a proof issue on least restrictive means. There's nothing we can offer that would allow them to assume the obligations. So.
We're at the time. So do you want to wind it up?
We're officially at the end of our time. We have about 15 minutes before the next session. If anybody has a question that they didn't want to ask in open, feel free to come up. And I also wanted to just point out, if you want a copy of the PowerPoint, please feel free to email me.
Thank you very much.
Thank you all for coming.
Thank you very much for attending.